acknowledges that this event takes place on the lands of the Blackfoot people and Métis Nation of Alberta, Region 3, and we pay respect to their past, present, and future cultural heritage, beliefs, and relationship to the land. SACPA commits to assist reconciliation efforts by raising awareness of the ways past and present injustices can be reconciled.
And today's speaker is Susan Ginther from Scotiabank, and she's a financial advisor. And also Pari De Silva, who is a business advisor, is here to support Susan with the technology. And then the title of the presentation is "You Can't Take It Without You." So what is that? Yeah. And yeah, we'll listen to that topic and see what Susan has to say and what she's talking about, that what we cannot take it with us, right? Okay, over to you, Susan.
Thanks so much for you all coming. I really appreciate it. Thank you to Dr. Walgama and the SACPA for having me. My name is Susan Ginther, and I've worked for Scotiabank for 32 and a half years. The last 18 of those specifically as a financial advisor. I love what I do, and I'm passionate about providing relationship-focused advice and planning. So, you can't take it with you, but with a plan, you can control what happens to your wealth and mitigate the issues that can impact your estate plan. Can everyone hear me? Oh, yeah. Okay, because I'm a really loud talker. Okay, so let's look at today's retirement landscape. So, 22% of Canadians plan to retire between 65 and 69. So that brings up a really good point on what the other 70-some% and when do they plan to retire. Life expectancy is a big impact on your financial plan. Currently, we have a life expectancy in Canada for men at 81 and women at 84. However, that every year, that seems to continue to increase. Retirement funding can come from lots of sources. 24% from employer-sponsored plans, 14% from registered savings, only 22% from government programs, and personal savings outside registered plans, about 9%. Top financial goals, 39% of people are just trying to make their day-to-day expenses. 39% are thinking about retirement. So this is an interesting stat here. The amount Canadians believe they will need to retire for the ideal retirement. 62% say less than $1 million, 25% is $1 to $2 million, and 13% of people say $2 million or more. Now, when you're thinking of retirement or being in retirement, it's not how much money you have, it's how much money you spend and how much your expenses are. 68% of the top retirement concern is being worried about not having enough money in retirement. So on to the next slide. So it's important to have a financial plan. Being proactive gives you the confidence, peace of mind that you're on track, the ability to see roadblocks, change the course, and avoid potential issues. 81% of Canadians feel that a financial plan makes them feel more on track to meet their financial goals. 65% more prepared in managing tough economic times. 60% more prepared for financial emergencies, and 50% on track to retire when they want to. 62% feel that they have the improved ability to save and continue to save. And 73% feel more confident that their loved ones will be looked after should something happen to them. Now that's a lot of numbers, so on we go. So how do we start? It just starts with a conversation. Our approach to planning allows us to fully understand you, what's important to you, and your priorities. We will develop a plan that never loses sight of your individual goals and flexible enough to shift with the changes. We will action your plan using product, service, and expertise that you need. And most important of this process is revisiting and touching base to ensure over time the plan continues to reflect your needs and is on track to meet your goals. Okay, next. Now, we're gonna just dissect some of the goals here. So these are things that are important to consider when developing a financial plan. Having these discussions, we can make sure that we're bringing in any partners we need for expertise, which includes your accountant, your lawyer, etc. Now, if you have a business, how does that affect your personal financial plan? Do you have a shareholders agreement in place to cover a passing? Does your business need key man insurance? Do you have a succession plan to pass it on to future generations? Or how does a phased out retirement look like for you? Travels and hobbies. Most retirement plans are, one of the most important things is doing more of what you love. So how long do you plan to continue that, or how long do you feel you're able to continue that? And what does the cost look like to you? Now, a major big one that's maybe not discussed enough is health. That's something we can't predict. However, there are some factors that we consider and think about. Your current health, genetics. This can give us an indicator on what health issues may affect you. Now, during our working years, lots of us would have had medical and dental plans through work. But do those plans continue through retirement? And if they don't, what's the cost to maintain those? Legacy planning. You can't take it with you, but you can leave something behind. And what does that look like? And how can we mitigate issues that may arise from leaving a legacy? Charitable giving might be very important to some of you. Do you plan to do it before you pass or after? Have you documented this or made your wishes known to your family? Now, the one thing we're going to dig a little bit deeper is the estate piece. Okay? All right, approximately what percentage of Canadians over the age of 55 do not have a will in place? So there's A, B, C, and D. How many people think it's A, 10%? B, 15%? C, 20%? D, 30%? Okay, so the answer is C. 20% of Canadians over 55 do not have a will in place. Now, for those who answered D, this comes back into play. 50% of Canadians overall do not have a will. Now, this is hugely concerning because people under 55 likely have children. So what happens? Those who do have a will, they're outdated. They no longer reflect your wishes. And if this is left unaddressed, this could lead to problematic situations for many families resulting in turmoil, uncertainty, and cost. So it's not just the people in this room, it's your family, it's your kids, making sure that they have an estate plan. You don't have to have a ton of wealth to have an estate plan. Okay. So, what is needed? To establish an estate plan, it consists of 3 components. Creating a detailed will that outlines who will oversee your estate and ensure the assets are distributed according to your wishes. Appointing a power of attorney to make decisions on your behalf if you're not able or you choose not to. Designate beneficiaries, particularly on registered accounts and insurance plans. Now, there was something that wasn't necessarily mentioned in here that I am going to briefly discuss. Personal directive, the health part of it, and what's important to you as an individual, and making sure that that is documented or on paper. Because what you want to happen at end of life or during your healthcare journey as you age is vitally important. And making those choices known to your family is important. Because if that isn't in place, who's going to make those decisions? Not your family. So those are things, and again, with the personal directive, it's about your kids, your grandkids. If there's an accident, something like that nature, I mean, things happen all the time. Being proactive is 100 times better than being reactive. All right, so choosing an executor. There's a couple things to keep in mind. Obviously, choosing somebody you trust, but also somebody who can do the job. There is so many responsibilities involved, so it's somebody who can really do the job. An executor must execute your wishes according to the will. If you do not choose an executor or you don't have a will, then your next of kin will be appointed to administer your estate, and in this case, the estate will have to go through probate, and your assets divided among your relatives according to the law of your province. You will not be able to assign specific assets to charity, to friends, or give more to a relative than another. Make sure you let your executor know that you've chosen them, him and her, to do the job, so there are no surprises. You may find out they don't want it. So make sure you have an alternate in mind. Now, I am briefly, just based on my experience in the branch world with the bank, multiple executors. Lots of people want to name all their kids to be their executor, and that can cause issues. Somebody lives in Fort McMurray, somebody lives here, somebody's out of province. So it's really important to spend some time in thinking on how that's going to work. Because again, they have to, if the executors are all to act on your behalf together, that means they have to be together. And that could be an issue. So definitely spending some time in thinking on how that looks is important. Now, review, review, review. Just because your will was okay 10 years ago, 15 years ago, 20 years ago, 5 years ago, whoever your executor is may be the same age as you. That's not going to help anybody. So age can be a factor, health can be a factor. What if they moved? So it's important not only to have a will, but to make sure it's relevant. Okay, on to power of attorney. A power of attorney is a legal document that allows one or more to authorize to manage your money on behalf of yourself. Among other requirements, you must be mentally capable at the time you sign any power of a document or any power of attorney for it to be valid. You can also make changes or cancel your power of attorney at any time if you're mentally capable. Now, the definition of mental capacity varies on the laws of each province or territory. Choosing a power of attorney. Again, it's got to be somebody that you trust. And make sure that they are going to care for your finances and property the way that you would have wanted. Having a power of attorney makes you more vulnerable to financial abuse. So ensure the power of attorney that you choose has your best interests at heart and makes the decisions in the way that you would make them. Talk to the person that you want to be your power of attorney before appointing them. Make sure that they can take on this role. You can also confirm if they're aware of their legal responsibilities as your attorney and discuss if they feel comfortable about making decisions on your behalf. Knowing what causes knowing what causes a power of attorney to end. As long as you are mentally capable, you can cancel or revoke your power of attorney. Check in to make sure your backup attorney also knows their role and duties in case your primary attorney cannot act. Remember, a power of attorney ends at death. It is only valid if you are living. When a person dies, the power of attorney ceases. Then the decisions about your estate will be guided by your will and your executor. Ensure that your power of attorney is legally valid. We strongly encourage you to obtain legal advice when making a power of attorney. Working with a lawyer helps to ensure that the document is accurate and valid. A lawyer can also help you understand what your attorney under a power of attorney can legally do and can help you think through the risks and benefits of choosing a particular power of attorney. I am going to come back to this because there also is a few more points to be added to that. If you need or prefer a power of attorney that only covers, let's say, Scotiabank products and services, each bank has a power of attorney document that is only relevant to that financial institution's products and services that you have. It does not cover anything at any other institution. It doesn't cover anything outside of that institution. So you cannot use it only specifically for the stuff that's held at the bank. Keep your power of attorney up to date. Again, review, review, review. It's important to review and update your power of attorney on a regular basis to avoid any future problems. For instance, you may wish to change your attorney if your original choice is no longer available or suitable. You may want to update the requirements listed in your document to meet your current financial situation. And you can change your mind. You can change or cancel the power of attorney at any time as long as you're mentally capable of doing so. It's a good idea to let your attorney know, or any financial third parties to know, if you've made a change in your power of attorney documents in any way. You still have the power. Assigning a power of attorney or assigning an attorney does not mean you lose control over your finances and property. As long as you're capable, you have the right to continue to manage your finances. If you sign a new power of attorney, that can disrupt any other power of attorneys that you have out there, including the one you might have signed at your bank. Okay, so this special circumstances. There are certain circumstances when your bank may refuse to act on your power of attorney. it doesn't meet the legal requirements, if you pass away, or if the transaction is deemed not in your best interest. The bank may refuse to act. Now, I want to just briefly chat on that. So, for example, if son comes in and mom has a power of attorney with mom, and he wants to take $10,000 to go buy Bitcoin. No, we're not going to do that. Unless it's outlined specifically in your power of attorney, we have a fiduciary duty to act on your best interest. Okay, now this, I think, is one of the most important slides that we're going to discuss. POA versus joint account. Now, some of you might think it's easier to add a joint account holder, and in some cases that might be true. But it's absolutely vital you understand the risks associated in doing so. A joint account is a bank account where two or more people have ownership over the same account. These rights can include for all account holders to withdraw or deal with the funds in the account, no matter who puts the money in the account. As a joint holder, you have equal share access to the account and responsibility of all transactions made through the account. In most cases, unless you otherwise state, the other account holders can make withdrawals or other transactions without your consent, and the funds may be subject to creditors or other claims might exist. So, for example, if you have your daughter on there and she gets divorced, those funds are exposed. If for some reason your son is sued and he's on the account, those funds are exposed. So those are important things to really note. A joint account includes right of survivorship, at least in the bank land. If you have a joint account, it's with right of survivorship. So that means upon your passing, the ownership of that account goes to the other joint holder. Okay, so with POAs in contrast, there are more limitations in place to ensure the POA is conducting transactions appropriately on your behalf. Now, this is something really important to note. POAs are not permitted to gift any funds to themselves or others in way of cash, check, draft, or other transactions unless otherwise stated in the POA document. So, and I have had this situation in the way that historically Grandpa gifted the kids Christmas checks. I mean, it's there. But the POA decided that there was enough to look after Grandpa for the rest of his life and would like to have dispersed some of the funds out to beneficiaries. We would not do that. So if you want that, it's important to clearly document that in your power of attorney. Because, of course, the POAs can only manage the account on the sole benefit of the individual. Okay, so let's draw this all together here. So developing a plan has many different facets. It means understanding your financial picture today. It involves looking at all your financial needs together as one plan and going through various elements of your retirement and estate plan. We often uncover various gaps that you didn't know existed. It can be an absolutely overwhelming process. Therefore, it's vital to understand your full financial picture and work with a strong network of professionals. And this does include accountants, lawyers, all of that. By working together, we can develop a customized plan to get you where you want to go at the best outcome. You just need to start. Now, we have put together some packages up here that includes a will and estate checklist, as well as some interesting stats and information. And of course, you're free to call and chat anytime you like. Thank you so much for having me and coming. Appreciate it.
I would take this opportunity to thank our many supporters here, and which, if not for them, that we wouldn't be able to have these weekly unique presentations that you were able to share your ideas and thoughts and discuss the issues of current interest. And if I fail, I will fail in my duty if I do not acknowledge the following entities or the individuals. Thank you very much for the LSCO for providing this space free of charge. And also thank you very much for you guys patronizing their lunch counter. And the University of Lethbridge for the ongoing support. Lethbridge Herald for covering our sessions. And then the wonderful writing of Joe Manio, and you can see probably tomorrow or early next week. And also the Rogers Community TV for covering our sessions and make all these presentations available in the Rogers Community TV and also SACPA website. The next week topic is by Kim Galuzzi, and she is going to talk about advancing agriculture and the events in southern Alberta, and also the changes to the Lethbridge district and exhibition, all the changes, how it affect the community here. And now we'll have our second session and most fun session, I would say, the question and answers. So I will request anybody who's interested in asking questions to line up against the wall here. And when you come up to the mic, please have your name and the question very briefly and in a very polite manner. And I would reiterate the fact that please do not have preludes or long stories, just the questions. And those who are uncomfortable coming up here, just write your question on a piece of paper with your name and funnel it through to me, and then I will do the job for you. And without taking much time, okay, it's the time for you to come here, and then can you stay up here? Yeah. Yeah.
Hi, my name is Henning Mundel, and first rephrasing that statement using a medieval statement which our daughter-in-law likes to quote, there are no pockets in the shroud. But I would like you to kindly elaborate more in terms of your choice of executor. In other words, the problems if the executor is out of province or even out of country.
Now that I am not a lawyer, so there is problems with that and acting, not only just from a time perspective and the fact that we need people in person. So it is important to keep that in mind and figure out what needs to be done to make it a lot easier, or choosing a different executor. I know that didn't answer your question, but go ahead.
Hi, my name's Amber Murray. Now, this is very timely for me because I'm just about 55, not quite, but without a will. And both my husband and I's parents have been messing around with executors and changing power of attorneys and all that kind of stuff. So we're right in the thick of it right now. So I have a question, number one, about wills. It's quite expensive to get a will done by a lawyer. So what do you think about the online will kits? And I just Googled the top 5. So about what do you think about us using that? And number 2, how can we talk our parents into choosing an executor that's closer to them rather than down here in Lethbridge? So those are my questions. Thanks.
Okay, I guess in the will kit, I'm sure is just fine for some people. However, you get what you pay for, and you get advice. So I still, even though it's a costly thing to do, I would still recommend going to your lawyer and getting the advice and getting a proper will done. Now, in the case of parents and that sort of thing and family dynamics, I feel you and I see it all the time, including my own situation. So sometimes I think if it's trying to get your parents to maybe talk to somebody outside the situation that gives the same advice that you've been saying. I find this a lot in my job. A lot of my clients that I've dealt for over 20 years. And so they'll come in, I'll tell them exactly what their daughter or son has been saying for years. Oh yeah, that sounds great. So that's maybe something I would suggest, is trying to leverage some outside trusted counsel to put it in a different way, something like that. And hopefully make the situation, because and I'm sure you have friends, family, whatever, neighbors. You get to the situation and it can be absolutely a disaster and ugly. From a cost perspective, from a tax perspective, from all of that. So proactive is the key here.
Hello, I am Katie Aurora. I have no retirement savings, and even if I were to start saving today, I mean, I have a background in like engineering, I can do the math. I don't think I will ever be able to afford to retire. I have 2 younger siblings. Neither of them will ever be able to afford to retire. My mom is in her 60s. She has a PhD. She's working. She's looking to probably continue working well into her 70s, because even though she actually does have some retirement savings, it's very likely not going to be enough to sustain her through an actual retirement. I noticed that in your presentation, you kind of, at the start, you kind of like said, like, Canadians, not enough of us are saving for retirements. We don't have plans for retirements. And then you kind of glossed over that to start talking about like, oh, we'll bring in your lawyers and accountants and help you make a plan. But when it's increasingly becoming the case that for so many of us, the current system just doesn't work. We will not be able to retire. There is no plan that will get us there because we just don't have the income to even think of making a plan like that. I guess, I mean, I'm a little frustrated. Hopefully, like, it's not coming off as like being accusatory to you, but it is a broader frustration for myself, for other young people. And it does get a little frustrating sometimes when, maybe I come to an event like this and thinking like, hey, maybe there's like some actual useful information that I could use to help saving for retirement. And then it's talking about power of attorney and executors.
Well, and again, this was the situation. Let me address that. So in no way, shape, or form do I demean or in any way demean that. I have kids, 30, 26. I have customers that are of all ages that struggle. And I'll give you a little bit of background on this. My parents, my mom worked full-time. She's 70 years old. And she has to work full-time. So yeah, retirement for her is completely different than some people. Financially, everybody from this side to this side, everybody's different. And yes, you're right, maybe you're not going to be retiring like I've alluded to or said, but we can sit down and listen to your situation. We can try and figure out products, services, and plans that can help you or motivate you or different ways of thinking about it. So yes, everyone in this room is very, very different financially. Very different. And no, it's not wrong, it's not right, it's only what is the situation. So it's important still, I think, to come in to your advisor and have a discussion. Is there ways we can trim things? Is there some advice? Is there some direction we can give you? Absolutely. Is it going to solve the problem or your frustrations? Probably not. But that's all we can do. But I don't mitigate the fact that some people absolutely do struggle.
Hi, my name is Terry Shellington. One of the things I appreciate about your presentation, by the way, are the crisp, sharp answers that, not a lot of baffle-gab, but some straight naming of issues. Anyway, when we go to pick an executor for our will or a power of attorney, most of us face very imperfect families. And, you know, Harry's got a drinking problem and Fred doesn't work and so on and so forth. So that's, you may have some advice about that, but my question is, what is the minimum age for people to fill those roles?
Okay. There is no, I would say, minimum age to fill those roles. It very much has to do with can they do those roles? Do they have the experience, the time, and the knowledge to take this on? Because to be quite honest, being an executor is different than it was 10 years ago, 15 years ago, 20 years ago. And not to be rude, it's a retina scan and a urine sample some days. That's how challenging it is to make sure everything is correct. And as an executor, they are responsible to make sure everything is complete and done correctly. Now, in those challenging situations, it doesn't work for everyone because there is a fee for this, but your financial institutions as a whole usually have some trust function. So you could name corporate executor, which means the trust company is your executor, and in a way, that still allows everybody to go have Thanksgiving together without problems. So there could be that as an option for you. It is maybe reaching out to your lawyer and having those discussions about your concerns, because it is absolutely vital from again, a time perspective, a cost perspective, to get it settled in a timely manner. And if there's infighting and problems, that's going to be an issue. Did I answer your question there? Okay.
Sorry to interfere, but I will rotate the question from the audience. And the question is from Bob. And the question, Susan, can you speak a bit about having a disabled adult child and how may affect planning your estate to leave same financial care for them? Did you get that question?
Yes, I did. That is a very specific type of question there. and very detailed and in depth. So for that question, I would specifically, I can leave a card here or whatever, but for sure, it's obviously making sure that you're outlining the care for your disabled child in your will and power of attorney and that sort of thing. But that is a little bit beyond my parameters, and I don't want to answer anything that I am unsure of. And I apologize for whoever asked that question. But yes, I mean, can I get you some more information on that? Yes, I can.
Thank you for your presentation, Carol Darmody. What are the current bank roles when, let's say, an elderly person is institutionalized and one of the siblings establishes a joint account and is corrupt, takes a lot of the assets? And what can the banks currently do with suspicious activity in joint accounts?
That is a tough one. Once, again, in the bank land, when you do a joint account, it is joint with right of survivorship. It is joint. So that causes some issues, hence the reason why I had that slide in here. I see people do that from an ease perspective, and it absolutely does not protect or do what it's meant to do. So my advice to you is if this is happening, go in and ask to talk to your bank manager. I can't, and then we can maybe do something from there, especially if there's something very much out of line. But that's the reason, that is exactly the reason why I absolutely do not advocate joint accounts, and there is a power of attorney in place instead.
Hi, my name is Ben Kwan. Just want to get your thoughts on an executor who's also a beneficiary.
So again, clarity is everything. So as an executor, which it happens in a lot of families, right? It's usually one of the siblings, typically the oldest one or the one that's closest, and they are a beneficiary of the assets. So, but again, that executor has a fiduciary duty to do the job that they were in placed to do. So they cannot, and as beneficiaries of the will, you have the right to question any of the other beneficiaries. It's the duty of the executor. They have to prove what's going on there. So again, there's some legal protection for the other beneficiaries to make sure the will was executed exactly how it was laid out.
William Retz. I got there was a couple of people brought up the fact that there was no real pension plan. They're going to be working until they're 70 or 75. That's something that, I mean, when I was younger, my parents pushed me to make sure I got a trade, number one, and to go a union trade, number two. Now, in these last years, I've really noticed a lot of people are working trades. They're not getting no pension. They have no designated pension. They don't even have 401ks with these companies. I've talked to young people, and I just shake my head like, who do you think is going to take care of your business when you're ready to retire? Because you ain't going to have no money coming in from nowhere. I talked to one kid, he says, well, that's not my thing. What do you mean that's not your thing? You got 10 years in the trade and it's not your thing, you're not even thinking about it. Yeah, I guess you expected the government to take care of them, But I think a lot of people, you know, they got to get more informed on this because it's sad. It really is. I've got friends that never worked union, and when I was younger, I kept telling them, hey, you got to get union, you know, so you got some pension in the end. And oh no, I'm making good money, rats. Yeah, you're making good money right now, but you're not putting any of it away. And a lot of people have told me, oh, I'll take care of my own pension.
Well, and
That's
I'll talk to that.
Okay, yeah, maybe.
You betcha. Okay, so in regards to this, that is where coming in young, coming in immediately, just because you don't have wealth doesn't mean you can't have a plan. And that may not be all the stuff on here. That may be the simple thing is, what's your expenses and what's your paycheck? And, you know, just talking through some of the options and things that are there. But you're right, generationally, some people don't think of that. So again, talk to your grandkids, talk to your families, get them in to see an advisor and start something.
Hi, I'm Dave Major. This sort of sounded pretty scary in places, so I thought I would just mention that I was the executor for my mother, who lived in Ontario, and my wife. And I worked through my mother's lawyer and our own lawyer, and we were diligent about it. We kept everybody informed about what we were doing, and we did it as quickly as we could. And both of them were settled without probate. And so it doesn't have to be scary.
Oh, it doesn't, but unfortunately, sometimes it is. Sorry.
Okay, I'm done.
So you betcha. Sometimes when there's an estate, it is not a problem. All the siblings get along. It's straightforward. It's easy to do. And I guess after 32 years with the bank, I'm slightly jaded because that doesn't seem what happens. So it's, again, you plan for the worst, and if it ends up working, great. That's awesome. Then it's not going to be a problem. But again, being proactive is 100 times being than reactive. Seeing the problems before they start or the potential just gives you the resources and the planning and the ability to address and prevent any problems from happening. So that's awesome, that's great, and you're right, that does happen. But again, if you plan for the worst and you get the best outcome, awesome.
Bev Mendel-Atherstone. It's quite interesting that you're here talking about our end-of-life planning, while outside the nursing students from the college are giving flu shots to help us not die. So please make sure you get your COVID shot. I mean, your flu shot out here, and your COVID shot too, but they're not giving that one. Okay, someone asked about a will planning for adults who have a disabled child. I have two answers. I'm not a lawyer, but I've been told this by our lawyer. One is the Alberta government, as it's currently stated, it wants to make sure that children of adults who pass away, children with disabilities, have a great deal of financial support. So if you are writing your will and you've got 3 kids and you give equal to each, they want to know why you're not giving that disabled child more, and they recommend that you keep lists of things if you've bought them a house or helped them with a house, or if you've helped them with medical insurance or whatever you've done, that you keep a list of all those financial supports. The second thing is, people with severe disabilities are under AISH, Assured assured income for severely handicapped. They use that old term handicap. They're not up with date that you use disabilities. Anyway, but the Alberta government, in its wisdom, has decided to take away AISH from all the people who are on it, and that will be done the year after next, 2027, and everyone will be put on ADAP. And ADAP is ostensibly a way for disabled people who want to work to work. So there is no indication that any of the benefits that are currently under AISH will continue on. One of the current benefits is that you can leave $100,000 to your disabled child in your will. They can have $100,000 now and use that throughout while you're alive, but you could, if they've used all that, nothing is left, you can leave another $100,000 to them in your will. This is called the Henson's Trust, so the money is put into trust. But there is no assurance that this will continue when AISH becomes ADAP, ADAP. Thank you.
I'm Lynn Gregson, and thank you so much for this very informative talk. This has been wonderful. I do have a will. My parents had wills, and they had set up everything for all of us in our family. We all, 5 girls each, had a job to do, and they did a great job of figuring out who was going to do a good job of each. So I was one of the executors of my parents' will. I have written my will. I have 2 executors. But when I was writing it up, I did talk to my lawyer, and I said, if they choose not to do this, do you have an executor in your office that can do this if they choose to go ahead with it? And she said yes, and of course there's a charge for that. But at least it gives my executors that option. Do you also, and do most banks also, have executors on your staff that do this as well in case they want to go that route? That's my question. Thank you.
So yes, we do have what's called, I guess at passing, if one of your executors wants to come into the bank and say, look, this is too much, I don't want to do this. We have what's called a state assist, which our arm of Scotia Trust will come in and assist or take over to do that. Again, there absolutely is a cost for this, but it is an option. So you betcha, because again, being an executor sometimes, for example, I'm the executor of my mom's will. I work full-time. I cannot get away to drive 4 hours to do all of their estate necessarily in a timely manner. So I may, if something, God forbid, happens sooner than later, I may just say, and you got to remember, the trust side of the banks do this every day, all day. So it is definitely a good option.
Sorry, the time is up, but I can accommodate one last question.
Again, thank you for your presentation. It was very enlightening. It occurs to me with regard to providing for a disabled or developmentally disadvantaged child that the idea of insurance could be a solution as long as it's an affordable solution. Not everybody could be able to do that, but you could make special provisions within your estate plan to provide insurance with that child named as a beneficiary, and the other assets be distributed more equally to the other children, as an example. So that was just something that occurred to me.
I'll just talk. to that for a sec. Now, in Branchland, we are not licensed to sell insurance. So again, that is in bringing in the experts. The accountant is definitely one to speak to about this, and certainly your lawyer. So again, I'm not going to get into the weeds on this too much because it would be bringing in other experts to make sure that I'm giving you correct and informed decisions.
Just a bit more information on that. In regards to a disabled adult child who is intended to receive an insurance policy or something to that effect, if they are on AISH, if they are currently on AISH, the government allows that $100,000 to be tax exempt. However, if they receive more than that amount or have more than that amount in their account, that is not tax exempt. Okay, just to give you that information. If you're not on AISH, of course, then that's a moot point.
Thank you very much for all the verbal questions and just one written question. And last but not least, Susan, if you have a take-home message, very briefly, to share with the audience, we would really appreciate.
Again, I can't thank you guys enough for having me. It is just have a plan. You don't have to have a lot of money. You don't have to, but if you put the dots on paper and you visualize it, that's when you can kind of see the ripple out effect. And so I really and truly encourage all of you to revisit that. Look at your wills, look at your power of attorneys, your personal directive, put some thought into it, and be prepared. Thank you so, so much for having me. Appreciate it.